can a confirmed death row inmate walk free if the victim's family forgives them?
Amr, surprisingly yes. In Pakistan, the ultimate power to punish often shifts to the family.
Wait, even if the Supreme Court itself has already confirmed the death sentence?
Ahmed, exactly. Today we're exploring how the Pakistan Penal Code makes that possible.
So we need to look at homicide types, blood money, and state power, right?
Right. We will start with how the law defines the act of killing itself.
Let's look at sections 299 through 338H of the Penal Code then.
These specific sections govern homicide and injury, setting up Qisas, Diyat, and Tazir.
The code basically outlines three main categories of homicide, doesn't it?
Yes.
Qatl-i-Khata is accidental, while Qatl Shibh-i-Amd is considered quasi-intentional. And the third, most severe category would be Qatl-i-Amd, which is intentional.
Correct. Section 300 defines this intentional killing through 4 specific categories of intent.
So it requires a clear intent to cause death, or knowing it's highly probable.
If convicted under Section 302, how exactly does the judge decide the sentence? It's a 3-tier system. First is Qisas, which is literal retaliation or death.
And if Qisas doesn't apply for some reason, what happens next?
Then Tazir applies, which means either death or life imprisonment. Or they can drop to the 3rd tier, a 25-year Tazir sentence.
This brings us to the wali, which completely flips common law on its head.
It really does. The state literally hands its power to the victim's heirs.
Section 305 formally vests the right of Qisas entirely in those legal heirs.
Meaning the grieving family literally holds the killer's life in their own hands.
Under Section 305, the wali actually has 3 immense choices they can make.
They can demand Qisas execution, accept Diyat blood money, or grant Afwa.
Exactly. Afwa is a full pardon. The state cannot commute without their consent.
Let's look at that second option, Diyat. How is the blood money calculated?
Ahmed, it is not arbitrary. It follows a very specific, dynamic financial framework.
The law sets a baseline equivalent to 30,630 grams of silver, right?
Yes. The exact rupee amount fluctuates with current open market silver prices.
That's a massive sum. Do they have to pay it all at once? Under Section 323, judges can authorize installments over a maximum of 3 years. And if the convicted person dies before paying the entire amount off, the remaining debt doesn't vanish. It becomes recoverable directly from their estate.
What prevents a wealthy killer from forcing a poor family to settle cheaply?
Amr, the Supreme Court addressed that in the 2016 Mohammed Iqbal case.
They ruled that Diyat obtained through economic coercion is completely void, right?
Yes, courts are obligated to ensure the compromise is truly a genuine settlement.
What if the family forgives the killer long after the trial is over?
That brings us to compounding under Section 345 of the Criminal Procedure Code.
Section 345 allows compounding Qisas offenses at absolutely any stage of the process.
Precisely. Even after a death sentence is confirmed by the High Court.
So a death row prisoner can be entirely released if the heirs pardon.
Yes, the Abdul Qadir case from 2000 established that genuine compounds are binding.
The court must give effect to it, shifting from punisher to mere verifier.
As long as there is no economic coercion, as the Iqbal case established.
So if a finalized death row inmate agrees to a verified Diyat payment,
Amr, the Sessions Court verifies it and the death sentence is legally converted.
And just like that, the Qisas execution obligation is entirely extinguished. But you might wonder, does the state just walk away from dangerous killers?
Exactly. What happens to the state's residual power in these pardoned cases?
The wali's right to pardon definitely extinguishes the right to Qisas execution.
But it doesn't erase the state's right to Tazir for public order, right?
Correct. These 2 distinct powers exist alongside one another in the justice system.
The 2017 Ghulam Qadir case tackled this exact residual authority issue, didn't it?
Yes, the Supreme Court ruled Tazir imprisonment may still apply after a pardon.
This happens in cases of public interest or where murders are particularly brutal.
Amr sections 332 through 338 apply this exact parallel logic to hurt offenses too.
So for amputations or wounds, Qisas retaliation is available if anatomically feasible?
Yes, and if literal in-kind retaliation isn't possible, courts default to Diyat compensation.
Balancing victim rights and public order forces us to reconsider defining criminal justice.
Exactly.
Is justice the state's impartial hand or the family's deeply personal choice?
Thanks for exploring the Law Simplified series on Pakistan Legal Insight with us.